Unfortunately, tenant evictions are occasionally a necessary evil in the world of owning rental properties. Today, we're going to dig into that process a little deeper.
Mama told me to come.
The problem here is, how do you handle a tenant eviction in the event of failure to pay rent or another breach of the lease terms? Going it alone without representation by a qualified attorney can be risky and uncertain. So today we're going to get into the question here. What is a tenant eviction? How does the process work? What steps need to be taken in what order? And how do you, as a landlord or as an owner, get the best possible representation through this process? So here to help us today is an expert in this field, a real estate attorney from Midland. As usual, we met originally through real estate investing back in several years ago. Meredith and I had actually purchased, renovated, and then resold some residential single-family properties, and he was the purchaser of those, and I believe still owns them today. We also met through the Midland Area Real Estate Investors Association. We were both members there at one time and got to know each other there a little bit. He's been in practice since 2008. He graduated summa cum laude from Alma College, where he got a bachelor's degree, and then magna cum laude from Ave Maria Law School in 2006. He was the Reader's Choice Award winner for the best attorney in Midland in 2009, 10, 11, and 2014. So very well respected and admired attorney in Midland. Currently resides in Auburn with his wife and 5 children. Holy cow. He's here today to lend his expertise in this field. John Gardai, welcome to the show.
Thank you, Logan. It's good to be here.
I want to read this real quick. This is from the Midland Daily News article a couple of years ago. Attorney John G. Gardai aims to educate clients on estate planning and other matters, and that willingness to explain and answer questions has earned him a Reader's Choice Award. He specializes in estate planning, landlord-tenant real estate, business organization, contracts, and other civil matters, as well as at times working as an appointed on an appointed basis in Bay County child neglect matters. Here's a quote from that article from John. I like working with people, sitting down and explaining things to them. Sometimes all the legal jargon can be overwhelming. So sounds to me, based on this article, that you have a very similar mission for your clients as we do here at Modern Realty to help create informed and confident clients.
That's exactly right. And that is what I most love, is taking a complicated legal matter and breaking it down, making it understandable for the client, and guiding them through the process.
Let's talk about that, because you and I just got back from the courtroom today, so this is fresh on our minds. But I want to go through, starting from the lease itself all the way down to eviction. We'll go through the process, help people understand what they're getting into, what to expect, and how it works. So first question of the day, discuss the language required to be in every residential lease. What are some things that you need to have in a lease?
Okay. And before we begin, if I could, Logan, I wanted to remind the audience that this is not intended to be legal advice. And of course, everybody out there should seek out their own attorney if they have legal issues. This is strictly for entertainment and educational purposes.
Well done. Well said.
Unfortunately, in the legal profession, we sometimes have to use language such as that, and now we're talking about language that must be in your lease. And a lot of times landlords ask, why should they have to have it? Well, because the law requires it. So it's pretty simple, and the tenant can make a lot of trouble on the back end if it's not in there. So first of all, there are 2 clauses that have to be in bold and at least 4 points larger than the body of the lease. Most leases have these because they've been around since the 60s, I believe. And that is a Truth in Renting Act one, and one about providing a forwarding address within 4 days of moving out. And so most landlords do have that. What I see that sometimes they miss is there's one about a tenant being able to move out if they qualify for independent living. So that would be normally a senior citizen, but someone with a medical condition. And there was a recent addition, and recent in this area of the law means within the past decade or so. And that was that a tenant with who's afraid of stalking or domestic violence, harassment type issues can also get out of the lease with certain conditions. And so that those clauses must be in the lease.
Okay. Additional terms that you typically see are, a start date, an end date, obviously a rental rate, security deposit amounts, fees for delinquent rent, fees for non-sufficient funds, things like that. What else? What other things like that? Basic terms.
Well, yes, there are certainly going to be a lot of the terms. You have to obviously define the property and the amounts and all that. Again, that's not normally something landlords struggle with, but the average lease might have 20 to 30 paragraphs, so we obviously can't cover everything.
Sure.
I did have a few, helpful things, if I could mention them for the benefit of landlords. One is that there is a clause that I see frequently about drug use on the premises. And that really ought to be in every lease, because if it is in a lease, the landlord has a special procedure that they can use to evict a tenant much more quickly in the event of drug use, drug manufacturing, that kind of thing. It does require a police report, though. It can't just be, I think I saw something type thing. Don't forget about the clause relating to lead paint. So if you have a house older than
78, I think.
78, yeah. Yes. Make sure that's in there.
Mm-hmm.
There is a fairly new provision in the law that allows a landlord, with the right clause again, to collect contact information should a tenant die. Now, you might not think of this too often, but if you actually have a tenant die, and if they were the only one on the lease, what do you do with all those possessions? Mm-hmm. Can you remove them? In the past, a landlord might actually have to start the probate estate himself. And so there's a procedure around that now, and it starts with the right clause in your lease.
Wow.
So you're going to want that. And the last clause I wanted to mention as a helpful clause is that landlords may now ban the growing and smoking of marijuana, including medical marijuana. And you cannot ban taking it in other forms. So you can't ban, I don't know if it's, it's in a brownie or it's in an edible or whatever they call it. But you can ban smoking and growing. And for most landlords, that's something you're going to want to do.
So even with the new laws now that have made that stuff more legal and more, tolerable legally, these landlord or these lease provisions can still prohibit that?
Right. So in general, a landlord, of course, can prohibit just about anything in their lease, in the written lease agreed upon. For example, most landlords will prohibit regular smoking, right? Mm-hmm. Cigarettes. Okay. And so originally, when the medical marijuana initiative was passed, a tenant could get around that because they had the right to use the medical marijuana. And then the legislature amended that to say that even if you have the medical marijuana card, a landlord can still stop you from growing or smoking. Now, for someone without medical, yes, it's legal, but again, that's just like banning cigarette smoking. It might be legal to do, but a landlord can still ban it up front in a lease.
Interesting.
Interesting. Yep.
Okay, moving on. Next question. So regarding security deposit situations, what things are required for a landlord to deduct from a security deposit or to keep it all together as a result of changing condition in the property? Okay,
so the first thing that's required is you have to meet all the criteria for collecting one in the first place. And again, I'm not going to go into everything, but you have to name the bank you're going to keep it at in the lease, the bank and address, and a contact information for the landlord, and have an initial checklist for the property.
Okay, so the tenant fills out the move-in checklist, and then when the move-out occurs, the property manager does a walkthrough, and if he or she finds a condition issue that doesn't line up to what was already there based on the move-in checklist, that's the parameters for which they can charge. So in other words, if there's a hole in the wall that wasn't showing up on the move-in checklist, reasonably they can charge for that.
That's certainly true, subject, of course, to all the conditions. The law allows a security deposit to be used for damage to the premises, unpaid rent, and unpaid utilities. It does not allow it to be used for cleaning, and so a lot of The things I talk to landlords about are the fine line between damage and needing to be cleaned. Also, keep in mind that the security deposit is limited to 1.5 months worth of rent, and that any refundable deposit is part of the security deposit. It doesn't matter what you call it. You can get cute and name it whatever you like. A pet deposit, for example. If it's a refundable deposit, it counts, it's lumped together, 1.5 months rent is the limit.
Interesting.
So you may charge a non-refundable, for example, cleaning deposit that would not get counted. But anything refundable is part of the security deposit.
Okay. So you got a tenant in place, you've signed a lease, you have helped them fill out a move-in checklist, everything is good to go, the lease goes, and then all of a sudden rent is late. So if your rent is due on the 1st, it becomes late on the 2nd, unless you have some kind of grace period already written into the lease, assume that you don't. And on day 2, what process can start in a worst case scenario if there's no good communication and we have to move forward in legal matters? What are the options for a landlord at that point?
Sure. So day 2 that the rent is late, they may of course send a 7-day notice, and that's a legal notice that the tenant is behind in rent. It states of course how much they're behind and gives them, as the name suggests, a 7-day period to catch up. Once those 7 days have run, they can then go to court.
Okay, so step 1 in this scenario would be to send the 7-day notice. That's a document that has 2 copies. One copy the landlord keeps, and one copy goes through first-class mail. It's regular mail. It gets delivered to the tenant that way. Typically, can also be hand-delivered.
That's right.
Okay.
Keep in mind that the one thing not to do is do not send it certified requiring a signature. Because what will happen is the tenant won't sign, and it'll come back, and it's as if you never provided notice. So
I did that once.
Just do it first class, simple first class.
That means one stamp, put it in the mailbox, you're done.
Absolutely.
Okay. You don't have to prove that they received it. You only have to certify that you actually sent it.
Correct.
And you do that by signing your copy of that notice and keeping it on file.
Yes.
Okay. So 7 days comes and goes, no rent gets paid. What are my options as a landlord moving forward?
Well, at that point, you can file a summons and complaint at the courthouse and proceed with an eviction case.
Okay, so at that point, after 7 days, I can initiate the court proceeding called a summons and complaint. That's what it's called?
Those are the 2 documents you file to start the process, yes.
And is that different than a 30-day notice?
Well, correct. So we've been talking about how to proceed under a 7-day notice.
Okay.
A 30-day notice is a different initial notice. As the name suggests, of course, it gives 30 days instead. A 30-day notice is not used for non-payment of rent. It's used for basically any other breach. It's commonly used when a lease has ended, so there simply is no more lease. Another breach might be that the tenant has somehow damaged the property, or that more people are living on the property than allowed. Or perhaps there was a no pets clause and now there are dogs and cats running around everywhere. So the 30 days, basically, you've done something else wrong other than just not paying rent.
Okay, so the end objective of a 7-day notice is to collect rent. The end objective of the 30-day notice is to end the tenancy.
That's exactly it. With a 7-day notice, if the tenant pays, you have to let them stay.
Right.
The 30-day is designed to simply get them out. Or occasionally, it can prompt them to correct the behavior, of course, and then you don't have to kick them out. But the 30 days is designed to get them out.
So if a tenant doesn't pay rent, can that be a cause to send a 30-day notice first, or do you have to go through the 7-day notice first? Or can you send both at the same time?
You can send both at the same time. However, non-payment would fall under the 7-day, not the 30-day.
Okay, and then if they paid, you couldn't ask them to leave if they've paid in either avenue, correct? In other words, if they pay, they can stay.
That is correct. You would need another reason for making them
for
leave.
the 30-day. Got it. Okay, so it's a protection for the landlord and for the tenant that if rent is not paid, you send the 7-day notice. If they pay it, it's done. They keep moving. If they don't pay it after 7 days, you do a summons and a complaint. You file for a hearing with the court.
Correct.
And from the time that you file that complaint, how long does it typically take, and what's the process from the date of when you file to the date you actually get into court? What has to happen and how long does it take?
Right. So under both kinds of notices, whether it's 7 or 30 day, You file a summons and complaint. Keep in mind the actual complaint is going to be different. There is a complaint designed for non-payment of rent and one designed for other breaches, essentially. The court clerk's going to give you the date. That tends to range out, 2 to 3 weeks or so, depending on the court schedule. The first step is to ensure that you have a process server lined up, because that person will need to serve the tenants on time, of course. So you get your hearing date, you secure your process server, and at that point you basically gather your evidence and wait for the court hearing to come up.
So this is when fees and costs start to incur for the landlord. They have to pay. There's a fee involved in setting a court date. Is that true? Or
There's a filing fee with the court.
Okay.
It ranges from $55 for if you'd like a possession-only type action where you're not going for a money judgment, and it goes up based on the amount of a money judgment you're asking for.
got it. And then also the process server. There's statutory fees on how much that can cost.
There absolutely.
Okay.
And if I remember correctly, it's currently $26 plus mileage per tenant.
In that range, give or take a couple bucks. So either you as the landlord have to initiate that process server, or if you're using an attorney, the attorney can coordinate that as well.
Oh, certainly. If you use an attorney, I mean, for my clients, I always take care of submitting it to the process server, filing all the documents and all of that. But yes, if you're trying to do it on your own, then you are responsible for
Taking care
for
of
all
that.
the forms. One of the things you need to file are envelopes made out to the tenant, because a tenant actually receives both a mailed copy and a process server copy. So two of them go out to the tenant. And so, there are all little things that you need to make sure you have in order, but it's once you get the process down, a lot of landlords do it themselves.
What about, is it true that if you own the property in an LLC, you have to be represented by an attorney, but if you own it individually, you don't? Is that accurate?
That is accurate.
Okay, so if you own your property in an LLC, you have to be represented by an attorney here?
Yes, because an LLC is a separate legal entity. So for a member of an LLC to go into court on behalf of that LLC, they would have to be an attorney. That's essentially representing someone who's not yourself. So that's the pros and cons of the LLC, is that you get limited liability. The reason you get limited liability is you've created a legal entity that's separate from yourself. So for that very reason, it also needs to be represented by an attorney.
Got it. Okay. So it's the hearing. You actually show up to the hearing. They're all done in Midland on the same day of the week, seems like, right? Middle of the week? Or?
Midland County is going to always be a Wednesday at 1 o'clock, yes.
Okay. So you show up there, you connect with your attorney if you have one, you wait until they call you in, you wait till it's your turn. When it's your turn, you're called up, you and or your attorney go into the chairs, and they start debating, the facts of the case. Your attorney, if you have one, speaks on your behalf and basically comes up with what happens from the time that you're called up. How does that work? Describe what you went through today a little bit.
So basically, the judge is going to ask a series of questions to each side to just ascertain what's going on. The primary thing the judge needs to determine is there actually a dispute? Very often, the tenant will come in and admit they owe the rent, or that they've done whatever they're accused of doing. So the judge is basically looking, is there a dispute? If there's not, makes it easy on the judge and he can enter that judgment. If there is, then the judge will need more time to figure out what's going on, and in that case there may be witnesses called, testimony, and all of that. So
and then of course if the tenant does not show up, the landlord typically wins by default.
Exactly, there would be a default judgment entered.
Okay, either way, whether the tenant shows up or not, let's assume here for this conversation that the landlord wins the case. At that point there's an order of eviction, is that correct?
At that point, there's a judgment.
It's a judgment. Okay.
Yes. So, and the judgment will give the tenants 10 days. If it was a 7-day notice, lack of payment, the 10 days is to either pay or get out. If it was a 30-day notice, then the 10 days is simply to get out, because it's, the payment's not part of the case. So either way, they'll have 10 days. Here in Midland, because these are always heard on a Wednesday, the 10th day is always a Saturday, so it extends to the Monday, but, so they really have 12. But they're given a judgment with that 10-day period.
Okay. And then so at that point, the tenant is still entitled to the property. You as the landlord have to be patient and go through the process here.
That's right. So as a landlord, the thing to keep in mind is you are not allowed to, you're never allowed to forcefully enter the property. You have to either wait until the entire process is completed or until the tenant voluntarily vacates.
Okay, and then you get through 10 days, and unfortunately you have a stubborn tenant or a tenant that has, really unfortunate circumstances, whatnot. They have not left the property. At that point, what's the next step?
So the next step is to go to the courthouse with an application and order for eviction, to file it with the court clerk. If it's a non-payment case and the tenant simply hasn't paid a dime, normally they will process it immediately. Depending on the circumstance, the judge may also schedule a new hearing to determine whether the order of eviction should be granted or not. So in the typical case, you come in, the tenant simply hasn't paid, you get your order of eviction. You take that document down to the sheriff to be served.
And then the sheriff physically sends a deputy and coordinates the move-out process in person.
Exactly. Well, what the sheriff is going to do is to serve the tenant or to post it if they can't find the tenant. Mm-hmm. At that moment, the landlord is in possession. So that's the moment where the landlord can use his key or break the door if he has to. He can enter, he can change locks, he can move the possessions onto the curb. The one thing to keep in mind, though, is that the sheriff is certainly not going to assist you in actually moving possessions or something like that. He's going to basically let everyone know where they stand and
facilitate,
take off normally. If things do escalate or whatever, be prepared to call 911 and possibly have the police or deputies called back out to assist. Okay,
so this process can be miserable, from start to finish, but it seems, at least in our area, to be pretty efficient. It's relatively efficient as compared to other markets or other states and things like that. But in order for it to be efficient, you have to really operate all the steps correctly. And I believe strongly that an attorney is required, or at least should be considered heavily when you are going through this process, either as a tenant or a landlord. But we're in the landlord lane here today. But because if you make a mistake, or you don't print out the right document, or you don't give the notice the right way, that can derail the whole process, and you have to start over, and or you can even lose and be not in a good spot, right?
That's exactly right. I would definitely recommend legal help. And even there are some free legal services that some tenants do take advantage of. And if the tenant has the means, they're of course welcome to hire their own lawyer. But yes, from the landlord side, unless a landlord is quite comfortable with all the steps, I would definitely recommend having that legal counsel there.
Having just gone through it today and witnessed it firsthand, it's really not a fun thing. It's really, it's not fun at all. And sometimes, like today happened, you can actually come to an agreement outside of the courtroom and solve problems out there. And whenever that's possible, that's a nice thing. But if you're in a tough situation where there is no amicable, reunion going to happen here, having an attorney speaking on your behalf and representing you, I think, is a really good thing to think about. And of course, John is very, very, very well suited to do that. He does it all the time. It's a big part of his daily operation. So I would certainly recommend John for anybody that needs that. If anybody wants to get in touch with you or ask you more questions, what's the best way for them to reach you?
Well, certainly they can give my office a call, 989-225-9053, and I'll be happy to talk with them and see what we can do. My office is located in the Rodney Chiropractic Building on North Saginaw Road, just across the street from Northwood. But please call first and we'll set an appointment, and I'm always happy to meet with someone.
Well, thanks for sharing your expertise with us today. Appreciate you coming in.
Thank you, Logan. I'm glad to be here.
Thanks.
I'm a tall and a